Welcome back to the Legal Alternative Podcast with me, Sam, joined but not in person by Nils. Nils, we're doing it remotely.
We are, first time, so we'll see how this goes. We'll see how it goes.
Yeah.
We got a meeting this morning, so apologies to the listener that I'm doing this from my son's bedroom.
Yeah, and I think the listeners, if they couldn't see the yellow Lego head in the background, probably guess the room in your house that you're doing it from. On the road, Legal Alternative Podcast this week.
Well, he's got as much hair as me.
Yeah.
So, he's at least got that in common with me.
Yeah, he's very happy too. So see if his face changes by the end of what I'm going to talk about. I think, Nils, I'm up first this week. I think to let the listeners be a bit behind the curtain with the podcast, that sometimes my case updates aren't provided by me, Nils. My wonderful team sometimes provide the cases for me that I'm going to talk about, and I've got a slight suspicion they're trolling me on this one. So shout out to James and Jess who helped prep the podcast. But yeah, I don't know if they're going to try and make a point with this case. So has got a bit of press attention because you'll soon see in the content of it. Case of Herbert versus Main Group Services, a scaffolding company. I think we've both acted for and against a few scaffolding companies in the past, Nils. And again, you're probably not going to be surprised by what's gone on. So the headline grabbing news in this case is that the employee was sacked on the spot during a row that she called her boss a dickhead. And this is found to be an unfair dismissal. So that's where it's got the big kind of comedy headlines from this. But despite the kind of bit of good humor in the press releases, as always, take the points out of this, because I think the general reaction to how can you call your boss that and keep you and you should have kept your job. As always, we've got a process issue, and really it's how this is being dealt with. To give you a bit more of the factual background, the employee was involved in a dispute where the employee found documents in her boss's desk about the costs of employing her, and that she thought in her mind that she was going to be. She's then said to the boss and his wife, if it was anyone else in this position, they would have walked away years ago due to the ongoings in this office. But it's only because of you two dickheads that I have stayed. Her boss has then responded, don't call me a fucking dickhead or my wife. That's it. You're sacked. Pack your kit and F off. So again, we're not having the greatest of language back and forth. Employees then sued for unfair dismissal. Hearing the judge in the claim has upheld that claim and found an unfair dismissal. Judgment really saying a few things. Firstly, obviously, as you'd imagine, biggest issue for the company is they dismissed her on the spot. It's pack your bags and go. So no process followed, no investigation, no disciplinary hearing, immediate dismissal. So procedurally, we've obviously have some severe problems. Despite that, the judge actually went further, actually sailed on the facts that as well as not having a fair process, that the company didn't have a fair reason, and held that they didn't act responsibly and reasonably in the circumstances. What the case goes into is the employee's background, length of service, no previous disciplinary issues, loyal service. And they found, whilst the language itself was inappropriate, this was in the kind of heat of the moment during an argument, and the intent that no reasonable employee would have actually found that to be gross misconduct. So judgment on two grounds really holds that the dismissal is unfair. That's resulted in compensation in the sum of £15,000 and also payment of legal fees, which surprised me. £14,000. Not in the judgment I've seen is it gone into why costs have been awarded. That is unusual. So then there will be some I'm guessing poor treatment in the case, and there must have been some cost warnings given here, but again, slightly surprising judgment. So again, for listeners, takeaways as always, process is key. You have to follow a disciplinary process, even if you believe that this case is nailed on, cast iron case. You need to follow that process. The other lesson that we both see a lot is companies and employers reacting very immediately on the spot. And actually, if they had given themselves a bit more time to think about this, would they be so upset and angry about it? We see this, Nils, a lot, don't we, in social media cases where employees put something on social media, the company reacts very badly, quickly dismisses. Well, actually, in the fullness of time, they may not have been so upset about it, or the damage to the company or the individual's not so bad. So, headline grabbing case. I'll get your thoughts in a second. I think slightly surprising for some people because of the language. I don't think this is giving, for any employees listening, any kind of carte blanche to call your boss whatever you want. But key takeaways. Company. Any thoughts from you, Nils?
There's lots. I could talk about that for a couple of hours with you, I'm sure. I think obviously the process point is, and I appreciate, I haven't read the press article or any press articles about this, but the process point, it's clear, isn't it, that a fair process wasn't followed there.
Yeah.
Well, I don't know if you know the answer to this, but the care that the individual was awarded, was that subject to any, is that after discount or?
No, again, I believe I think we're thinking along the same lines. Again, in the copy I've got from the judgment, that seems to be a full award. No contrib. These cases for me are classic Polkean contributory fault type cases. So I think it's because it's not just that technicality. It's not just been found as just a procedural deficit. It's also a finding of that the employer's not acted reasonably in dismissing. Slightly surprising for me, I would suggest.
I would have advised that dismissal, if we got the procedure correct, I would have thought dismissal is within the band of reasonable responses there.
Yeah, again, that's why I think I think I would advise the same way. I think the context of those comments, it's you two dickheads. It was perhaps being seen not as in an absolutely negative way. It was more saying that in a colloquial term maybe help them. Again, I'm clutching at straws a bit. I think I think I would view it similar ways to you. And we'll see if this gets appealed. But it's a slightly surprising decision, I think, but one that I think we both, it's a good lesson for employers. It's that process. Take advice straight away. If they'd have gone away, even if they'd have suspended use of language, go home, then sort the issue out, I think they'd have been in a lot stronger grounds. They may have thought, actually, after they'd suspended us, started a disciplinary process, mitigation was brought up about length of service, clean disciplinary record, they may themselves have found a lesser sanction. Interesting one.
Very interesting. Just one last one from me. The costs, I found that really surprising.
Yeah. Again, I'll do some more digging on that, Nils, in the judgment. I've only seen the press release on it, so I'll do some digging on the judgment. But I'm with you. We both. It's very rare. Probably acting at Chadwick Lawrence, we see 1 or 2 cost orders a year maximum. So it's absolutely not par for course. I'll do some digging on that, and maybe we can do a bit of a costs update one week. Yeah, be good.
Well, my update's nowhere near as exciting or colourful as yours. I'm just conscious that the lead up to Christmas in particular is silly season, really, in terms of visas. It's really, really busy. And I just wanted to make the listeners and viewers aware of potential things to think of.
Yeah.
Because a lot of people think that you can instruct a lawyer on the Tuesday, and then by the Friday, you jump in on the A330 over to the UK from wherever you're currently living. But there are some hurdles that almost always need to be cleared. And it actually tends to be, I've made a list of, I think 7 or 8 here. And it's almost always one of these things. So the first one is, has the employer considered that the role can actually be sponsored, particularly in light of the new rules? Is it at the right skill level? Is it at the right salary level? Or are we going to have some sort of negotiation on that with an individual? Even if that role can be sponsored, is that individual that you would like to bring in or renew likely to be able to be sponsored? So what's their English language skills like? What are their finances like? If the finances aren't good enough, are we going to certify maintenance? If you don't have a license, you inevitably have to factor the time in that will take. My advice to people would be, if you don't currently have a license, to get somebody into the country this year is going to be extremely difficult. So you've got to factor that in as well. Even if you have a license, it's not uncommon for us to jump on a call with a client. We look at the sponsorship management system, and they've actually used all the certificates of sponsorship that have been allocated. At the moment, if you don't use a priority service, it's taking 18 weeks alone just for UKVI to say, have another extra certificate of sponsorship. So again, if a client were to phone me today and say, I've got a license, I've got someone from America, just for argument's sake, that we'd like to bring into the country, but we don't have a certificate of sponsorship, we've used them all this year. Unless we can get priority, that person won't be joining the business this year. Can the company afford it in terms of the immigration skills charge and the costs overall? These are all upfront costs. As a general rule of thumb, I always say, for a very straightforward immigration visa, you're going to be looking at spending £10,000. Is that something the company wants to invest in and pay up front? And finally, switching visas isn't always easy either, particularly now the new rules are coming through. And I'm just conscious in the lead up to Christmas, if you've got your ducks in a row and all those issues are ironed out, you're giving yourself a chance to get someone into the country and into the country quickly. If any one of those things is slightly out, there tends to be huge delays.
Prudent advice as always in terms of the cost as well. Cost of your role, and then adding 10,000 to that is, I think is a useful rule of thumb. As always, it's this recruitment challenge planning, workforce planning, is going to be critical. From employment side, we're still waiting on employment rights updates, which is going to further workforce planning. So I think that's, music to recruiters' ears, who I know are having a bit of a tough time at the moment. But that workforce planning piece, Nils, I think, as you say, is just critical.
Yeah, absolutely. So hopefully that's helped some people who are listening.
Perfect. Out of the office this week, I think, is this, Nils. We're both without each other today. I think we'll back as normal next week. I gave a little plug to the seminars last week. I do the same. Lots of exciting events and mock tribunal. I think this absence event that we're doing, I mentioned employment updates. We are waiting some with bated breath or not. We've obviously had the reshuffle time of recording this, Nils, last weekend. We've got a new employment secretary of the state, so we've had a lot of changes in the senior positions. Will that have a knock-on effect on these kind of proposed changes under the unemployment rights bill? Will that be watered down a lot? We will see. And anything, as soon as we do see, both the seminars and obviously this podcast place will update people.
Absolutely. If I could just mention one more thing out of the office, it would be remiss of me not to mention Huddersfield Town's brilliant start to the season.
Absolutely.
And I'm looking forward to going to Bradford City for the first time in 20 years.
Yeah.
This Saturday.
It really is. League One is the Yorkshire League at the moment, isn't it? I think at one point all the top 5 or 6 were Yorkshire based. So good, exciting league to be in. Leeds United steady start for me, but we'll see. Could do with a striker.
Well, yeah. I think it's going to be difficult, isn't it?
We'll see. Confidence as always.
Yeah.
So I think we'll be back in person next week. Lovely to see you remotely, Nils, and it's goodbye from me.
And goodbye from me and Lego Man. See you later.
I'm a Lego Man. Bye.
Bye-bye.